Supplemental 4, People versus Michael Campbell, 2554 FH.
Ready, Judge. Torso, the public defender anticipating appointment on behalf of Mr. Campbell. Mr. Campbell, please state your name for the record.
Michael Campbell.
You hear us okay, Mr. Campbell?
Yes.
All right, today's the date and time set for a violation of probation hearing. Mr. Campbell, you were arraigned on Monday. Judge Slay, I know there was the recommendation of probation placed on the record. Mr. Feaster, what are we going to do today? Actually, hold on. Didn't give Mr. Emmons a chance to appear. Again, trying to keep it. Okay, all right, so what are we doing today, Counsel?
Thank you, Judge. My understanding is that Mr. Campbell wanted to enter a plea to resolve this matter on Monday, and he still hopes to do that today, Your Honor.
All right, he'd be pleading guilty or no contest?
The records indicate that it was a no contest plea to the violation, and I believe the recommendation is to reinstate with 90 days of SCRAM tether, Your Honor.
That's what Judge Slay's notes indicate. And Benetti, is that still an accurate summary?
Yes, Your Honor, that's the recommendation.
All right. Mr. Campbell, do you want to proceed today?
Yes.
Okay, I'm going to have you raise your right hand to be sworn in.
You swear or affirm that the testimony you're about to give will be the truth, the whole truth, nothing but the truth?
Yes.
All right, you can put your hand down. You understand the plea agreement is that you're pleading no contest to the violation as alleged, and that there is a recommendation that probation be reinstated with an additional 90 days of a SCRAM tether. So that's what's on the table right now. Do you understand all of that?
Yes.
You want to proceed with that?
Yes.
Other than what's been stated on the record, has anyone promised you anything to get you to plead no contest?
No.
Has anyone threatened you in any way to get you to plead no contest?
No.
And is the decision to plead no contest yours to make?
Yes.
You understand that even though you're not contesting this, I have to treat it like a guilty plea, correct?
Yes.
All right. And the no contest plea basis is?
Potential civil liability, Your Honor, and I believe there's also lack of recollection, according to my notes. According to Ms. Benetti, I believe he also has an open case, Your Honor.
That's not a basis for a no contest.
It's not.
So we're
Yes.
good there. So we'll just go either or the civil liability and lack of memory. So, sir, you understand you would have had the right to have a hearing in this matter, correct?
Yes.
That hearing would have given you certain rights, including the following. At the hearing, you would have the right to require the prosecutor to prove by preponderance of the evidence that you violated your probation as alleged. At the hearing, you would be able to question any witnesses through direct examination of witnesses for you, cross-examinations of witnesses against you, and if you needed witnesses to appear, I'd order them to appear by subpoena. So do you understand that?
Yes.
Also, at the hearing, you would have the right to remain silent, meaning you could choose to not testify. That silence would not be used against you, or you could testify if you wanted to. You understand that?
Yes.
All right. And that by giving up or waiving or pleading, you're going to give up the hearing and you're going to give up all those rights. Do you understand that?
Yeah.
Okay. You're also going to give up your automatic ability to go to the Court of Appeals. If you didn't like what happened after that hearing, you could automatically go to the Court of Appeals without any question. But by not having the hearing, you have to ask the Court of Appeals for permission to take the case, and the Court of Appeals is going to decide that, not me. So you're giving up your automatic appeal. Do you understand that?
Yes.
All right. Looks like on February 22nd, 2021, you were sentenced to 2 years of probation for the operating while intoxicated, impaired, or under controlled substance influence, third offense. That was a maximum of 5 years incarceration or a $5,000 penalty. And it was alleged that you violated conditions numbers 1, 10, and 13 of your probation. I understand that you have some lack of memory or you're concerned about civil liability. So let me ask you, how do you plead to those violations?
No contest, Mr. Campbell.
No contest.
All right. And you understand you're not contesting those allegations as they are laid out, correct?
Yes.
All right. I think I did have a chance to look at the police report that is identified in the warrant, Pittsfield Township number 2200071145. And it was the allegations were detailed in there. So I believe that there's sufficient information in that police report to support the finding that the defendant is responsible for the violations. Counsel, would you agree with that?
I would, Your Honor.
People are satisfied.
And have I complied with MCR 6.4405?
People believe so.
Yes, Judge.
All right, I believe I've complied with the court rule as well. I find the defendant's plea of no contest is knowingly, understandingly, voluntarily, and accurately made. I am satisfied that there is a factual basis to support the finding that you are guilty of counts 1, 2, and 3, contrary to conditions 1, 10, 13 of your probation restriction by your probation requirements. In the warrant that is dated October 19th of 2022, and I will accept your plea. Sir, do you object to me proceeding to immediate sentence in this matter?
No.
All right. Let me ask Mr. Emmons or Agent Benetti, is there anything you want to add before I proceed?
Nothing people do.
Nothing other than guidance on whether the SCRAM is going to be installed in jail or not.
You have a preference.
Probably in the jail, based on that to be serving for an orderly like third offense, but I would leave it in discretion.
Okay.
If I might.
You might. You know I'm getting to you.
Yes, Judge. I know Mr. Campbell's one concern when I met with him this morning is that he was under the impression that he was already allowed to leave had a SCRAM tether previously been installed since Monday. So he thought he was waiting Monday, Tuesday, and today to have that installed. He is hoping to have that installed as soon as possible. And if that can't be for a long time, he'd ask to be able to report to be able to have that put on if the jail cannot do that in the near future, Judge.
There's nothing in Judge Slay's notes to indicate that he was released
Okay.
Monday at his arraignment.
Okay.
I don't know what I assume that the timing, I know I've already said today, I shouldn't make assumptions, but I assume that it's not going to take a long time for the tether to be installed.
Okay.
So, do you know any differently?
I believe Judge Slade, from what my notes say, did order that he was allowed to be released. She ordered it today, that he could be released if the SCRAM was installed before today. I think it is not installed, but I believe somebody can get out there.
Can I?
Right. So I'm ordering all right. So getting ahead of myself. In addition to those sort of like huge informational data points, do you have any allocution on behalf of your client?
Just, Your Honor, that he is working. He indicates he's trying to get back to work. I believe he's at risk of potentially losing his job, and he might tell you that if he's not able to get out of jail in the near future. So he's asking Your Honor to follow the recommendation of probation. He will comply with the tether, and I think that's generally what he wanted me to say. So if there's anything else, I guess he'll tell you, Your Honor.
Okay. And is there anything you want to say before I impose sentence, Mr. Campbell?
Yes, it's something I do want to say. I've been in here for like 2 days. They said that they was gonna put the tether on or whatever, and I need to get back to work. And it's not a problem with me getting the tether on. If I get a PR, I will go over there and do it myself. I'm not a flight risk or anything. I turned myself in to you guys. They didn't come get me. I turned myself in. So I'm just asking, can I please get a PR so I can get back to work so I don't lose my
I
job?
totally get that. Mr. Campbell. Well, let me offer you this. Like, you were charged with operating while intoxicated, impaired, or under the influence of a controlled substance, third offense. I haven't read through your whole file, but I'm going to guess that probably represents more than 3. Just going to advance that as a possibility. And I'm concerned because it's the alleged violation was possession of alcoholic liquor in a motor vehicle, consuming alcohol, and having in your possession ecstasy tablets. So that doesn't give me a whole lot of confidence that if I let you out today, that you might not go out, drive drunk, and kill somebody. And who would the headline?
Mr. Campbell.
Mr. Campbell, it would be Judge Conlin letting somebody out who killed somebody while you were drunk. So there's no question you're not getting out of jail till that SCRAM tether is installed. My assumption, sorry to assume, is that if I order it and I order your release, once the tether is in place, they're going to do everything they can to get the tether on either this afternoon or first thing in the morning. So I think it's going to happen, but I do not feel comfortable releasing you under your own devices to report, because frankly, Judge Slay's notes also indicate that you knew about this warrant 6 months ago and didn't turn yourself in until now. So none of that gives me a lot of confidence. I'm hopeful that we're going to get through this and I'm not going to see you again and you're going to successfully treat this and never be a threat to society again. But I can't be negligent in my duties. So you may be released once the tether is in place. And so it is the sentence of the court that you are reinstated to probation with all terms and conditions previously ordered, with the additional term that you have 90 days under a SCRAM tether to be installed prior to your release. So you do have the right to appeal what happened today. Mr. Feaster can get that form to you. It has all the information regarding your appeal rights. The important thing that you need to know as far as today is concerned, though, is that you do have to ask the court in writing for counsel to be appointed to represent you if you can't afford it. So, Mr. Feaster, can you confirm that you'll get that to him?
I can, Judge.
All right, so that concludes the hearing. I'm hopeful, Mr. Hudson, that you're out today with that tether in place, okay?
Thank you, Judge. You're all set, Mr. Campbell.